In the Sullivan case, though, Sullivan had taken a drug he'd been prescribed by his doctor, and that smoking cessation drug gave him psychosis, which led to a suicide attempt, and then turned to him attacking his mother. What's your view on Sullivan as compared to Chan and the strength of the two cases? Because in the Chan case, he took the drug recreationally. What other things are happening on the fact level here?
Well, you're right that Mr. Chan did consume the mushrooms voluntarily, but ultimately in both cases, neither man took a drug in such a proportion that you would expect to have the reaction that either of them had. So, although one of them was a suicide attempt, the other one was recreational drug use. There is a big difference between, voluntarily getting yourself to a dangerous state and taking a drug that may or may not be illegal, but with no reasonable foreseeability that you would get to a dangerous state of intoxication, never mind no foreseeability that you would go ahead and commit a violent act.
So Connor, similar question. Why is it that these two cases, which I see the similarities, but they do have some big differences, why are they being heard together?
Well, that's a great question, Christine. I think that there are material differences between the two cases, including the nature of what happened when the two individuals took the intoxicants in question. But both cases do raise similar issues. And those issues relate to the constitutionality, the purpose of this provision. And so the Supreme Court of Canada, this case actually came through the Ontario court system sort of in parallel, side by side. And so the Ontario Court of Appeal heard the two cases together. And so it made its way up to the Supreme Court of Canada together as well.
So Ari, there are constitutional arguments being made here. What exactly are they? What is it that Sullivan and Chan are saying is unconstitutional about this part of the criminal code that makes it, the defense of automatism unavailable if it was self-induced intoxication?
It's a very simple argument at its core that Parliament back in the 90s, to address the fallout from the case I described prior to the break, put in a change that was unconstitutional. We don't punish people for things that they don't have a guilty mind for, things that they don't intend to do when they don't even control their own bodies. They essentially prevented a viable defense. Doesn't mean it's going to win, Christine. This is the key that people forget. It doesn't mean the defense will win. But when Parliament takes away somebody's right to make fair answer and defense, and full answer and defense, and by the way, when Crown experts, let's not forget this, this isn't some defense-y thing where somebody shipped in, from Timbuktu to say, this is our theory. But when the Crown experts agree that somebody's not in control of themselves, the constitutional argument was very simple. We don't live in a country where we punish people for a rape, an attack, an assault, a general intent offense. We don't punish them for drinking and give them a sentence for the offense. We punish people for what they actually intend to do. And again, that's the core of the constitutional argument, which is in this country, we punish the morally guilty. We don't call people criminals or put people behind bars that are not criminals. That's the argument at its distilled core.
Now, Connor, you were involved in the case with representing an intervener called Advocates for the Rule of Law, and you also made constitutional arguments that were slightly different from what Ari's described. What were your arguments in about a minute?
That's right, Christine. So with Jordan Honigman, we represented Advocates for the Rule of Law on an issue related to declarations of constitutional invalidity. And at a very basic level, there's a provision in the Constitution that says the Constitution is the supreme law of Canada, and any law that is inconsistent with the supreme law of Canada is of no force and effect. Now, this issue arose in this case because back in 1999, in a case called Regina and Dunn, the Ontario Superior Court actually struck down this law. It found that the law was unconstitutional and declared it of no force or effect. The issue that arose in this case, in Sullivan and Chan, was whether that declaration was binding on the Superior Court. That is, the Superior Court simply had to follow the decision that came before it. That issue was litigated at the Superior Court level. It was litigated at the Ontario Court of Appeal level. And now it's before the Supreme Court of Canada, who will decide really what is the nature and scope and effect of the Section 52 declaration.